Good evening, trust you're all doing very well. Contract conditions and administration. That's the course title with the code KUS 325. This course is designed for us to be able to draft conditions of contract as well as understand and interpret terms and conditions when we are faced with this in our future endeavor. That's why practicing as quantity surveyors, especially when we are working for contractors. And if we are working as consultant quantity surveyors too, in most cases, we are usually the ones who draft the conditions of contract. It is therefore very important for us to understand how these conditions are drafted and to be able to interpret these conditions whenever we are given as contractors, quantity surveyors, as the case may be. So let us start by first of all defining the terms and conditions of contract. But before then, let's have a look at what we did under contract law. So in contract law, we were told, or you were told rather, or you were taught that a contract is an agreement between two parties with the purpose of or with clear intentions and indications of what the object of the contract is all about, and with the intention that the other party should accept the terms if he or she is satisfied. More importantly, with both parties having it in mind that this contract would be guided with the intention to create legal relations, which means that if either of the parties is is accused of breaching the contract in future, the other party can seek redress in the court of law to ensure that that party fulfills its rights, or it could seek a compensation for damages that may have arisen as a result of the breach committed by the other party. So, with this, we understand that in every contract, there must be terms and conditions. These terms and conditions are guiding the contract directly, not indirectly. Because the saying that where there is no law, there is no sin plays a vital role here. Once the terms are drawn, the terms and conditions are drawn, they must be complied with. Otherwise, we say that there is a breach of the contract, and that will now entitle the injured or the offended party to claim rights and damages from the other party who is being accused of having breached the contract. Further, let us now look into what we mean by terms and conditions. So we have all at one time or the other been engaged in different forms of activities, and we know what terms are. When they say terms, it simply follows that there are like rules or set of rules to be complied with or to be obeyed for a particular transaction. So once that those rules are set, they must be obeyed and they must be complied with. The conditions, like expansion of the terms, expanding the rules further by stating the criteria that are required to be carried out or to be followed in that contract. Therefore, you have terms, you have conditions, just like we have in every other interactions. For example, if you want to buy something now, maybe from the internet, they will tell you terms and conditions apply. Sometimes they don't write out those terms and conditions, but once they say terms and conditions apply, they are indirectly safeguarding themselves that if anything happens, they will now bring up those terms and conditions. In most cases, when they are not written, it may be something like a fraudulent act. In some other cases, the terms and conditions are written in very tiny ways, such that the person interacting may not even be able to understand. You may not even pay attention to it. You will not even read those terms because, like I said earlier, they are very tiny and you don't pay attention to it. But if something now goes wrong, the company will be quick at bringing it up by saying that they have already inserted the clause that terms and conditions apply, and they now bring up those terms and conditions. This lecture is mainly to bring you to give you an introduction into what the course is all about.